You can tell the academics are here because there are two backpacks at the back of the stage.
Good afternoon, everyone. Starting the afternoon session here, I harken back to what Gary Roberts said when we first started out, which is that this is a symposium filled with rock star presenters. This panel, the people to my left and right, are no different. To my immediate left is Sherry Diamond. Sherry is my former law professor, the best I ever had. But also currently still
I paid him.
a professor of law and psychology at Northwestern University Law School in Chicago. If that wasn't enough, she's also a research prof for the American Bar Foundation. And she's an elected member of the American Academy of Arts and Sciences. This is big league stuff. Sherry's research at the junction of law and psychology reflects also an interest in trademark law and surveys and how expert testimony is brought into our litigations. She is the author of the Reference Guide on Survey Research, which is in the Federal Judicial Center's Reference Manual on Scientific Evidence. For those of you who don't know, that is the book that Article III judges look to when they are confronted with complex technical evidence in federal lawsuits. She's also the author of, or the editor, I should say, of this new treatise on trademark and deceptive advertising surveys. David is going to be distributing some flyers.
They're going around now.
They're going around now that you can purchase this book at a discounted rate. It is pretty amazing stuff. It's probably the new go-to book on surveys and trademark cases. Next to Sherry is Jerry Ford. Jerry's principal and co-founder of Ford Bubal and Associates, marketing and management consulting company in Huntington Beach. Jerry and his team have been designing surveys for over 30 years now.
Yes.
He's a professor emeritus at California State, Long Beach, where he was a professor for more than 25 years. And Jerry contributed a chapter to this book on trademark surveys. And he's also the author of a chapter that's about to publish in a new treatise from Dan Berenskin. It's going to be a treatise on international dilution law. To my right is Eric Goldman. He is the professor of law and director of High Tech Law Institute at Santa Clara. He is also a highly renowned blogger. ABA Top 100 blog at blog. Let me get it right. It's just Eric Goldman, right?
EricGoldman.org.
Yep. His research has focused on internet issues and deceptive advertising issues. Down at the end, David Franklin, the man who needs no introduction here, other than to note that some of David's recent research interests have revolved around the empirical evaluation of the use of surveys in trademark litigation. I'm Eric Maurer. I'm an attorney at Banner & Witkoff in Chicago. My practice focuses on litigation, enforcement, and counseling in IP matters, but a lot of trademark cases. So, do we have the, there we go.
Yep.
Due to the sheer number of cases that talk about surveys and trademark cases, we split this session into four sections. Jerry, Sherry, and I are going to be talking about likelihood of confusion and secondary meaning surveys. I'll be talking just a little bit about delusion surveys in particular. Eric will be talking about surveys and false advertising cases, and then hopefully David is going to tie it all together with that round out on what does the empirical world look like in terms of how surveys are actually being used. So we'll dive right in with the first section, which is likelihood of confusion and secondary meaning surveys. And to frame the background here, we thought it would be helpful to go back to the promulgation of the Lanham Act in 1946 and just look at what the landscape has looked like in terms of the number of reported decisions discussing surveys in trademark cases. Now, the chart that's up on the screen now shows the average number of surveys per year, and you can see that there's a significant increase over the years. You'll see that from the initial 15-year period between 1946 and 1960, there were only about 18 surveys discussed in reported decisions. In the second block, there were 86 surveys for an average of about 6 a year. And then we get into the 1970s to 1990s, and we see a significant uptick in the average number of surveys per year, where there were 442 surveys offered and discussed in reported cases. Between 1991 and 2005, there's an even more significant jump. We're up to 742 total surveys for an average of 49 per year. And in the last 7 years, we've been running at about the same rate. Obviously, we're not done with that period, but there have been about 45 reported decisions discussing likelihood of confusion and secondary meaning surveys and reported decisions. So what fueled this dramatic growth? And it's important to note, David's going to talk at the end about the actual, the impacts of surveys in these cases. These numbers are reflecting reported decisions that talked about surveys. It's not necessarily the full story. There may be more survey work going on out there. These are just cases that happen to talk about surveys. So it probably is an indication of obviously the number of surveys that are being done in these kinds of cases and what would be driving that. Some people think there are two things that are behind the increase. One is in 1960, the publication of the Handbook of Recommended Practices for the Trial of Protracted Cases. That document ended up becoming what we know from the Federal Judicial Center as the Manual for Complex Litigation that we talked about earlier, that Sherry is a contributed author to, and that is that go-to guide for federal judges. Those resources laid out the criteria that courts could use to evaluate survey evidence. And up on the screen are some examples of the things that the manuals talk about in terms of evaluating this kind of evidence. Looking at the appropriate universe, looking at the representativeness of the sample, ensuring that data was being accurately captured. So those are things, starting in the 1960s, that probably led people in courts to be more comfortable with survey work in these kinds of cases. The next thing going forward a little bit is to 1975, and passage of the Federal Rules of Evidence, and specifically the 700 series of rules and Rule 703 that deals with trial procedures for expert testimony. And again, here we get guidance provided to the courts on how to deal with this kind of evidence, because I think judges are sometimes nervous about this stuff. It's numbers driven, it's science, it's technical, and it's not the kind of thing that they ordinarily deal with. So those two things likely drove that increase that we saw in the number of reported cases talking about surveys. There were some interesting things going on in the background about the actual admissibility of these surveys. At the outset, surveys were routinely challenged and frequently excluded on the basis of hearsay objections. Often surveys would not be admitted into evidence. However, then we went through a period in which there was a significant increase in the number of surveys that were actually allowed, and courts started saying, you know what, this isn't an admissibility problem, it's an issue that really goes to the weight of the evidence, so we'll allow all the surveys in. And then we're coming to a period where courts are once again a little bit more hesitant about admitting surveys into evidence, and the driving force behind the new shift in the landscape seems to be the DAUBERT line of cases from the Supreme Court and the DAUBERT progeny that set forth specific guidelines for the courts when addressing technical expert evidence. So with that, we're going to turn to Jerry, and we've gotten just about to the modern time of survey evidence. And Jerry.
Thank you, Eric. Well, first let's take a real quick look at the recent volume of survey evidence. In 2011 and 2012 combined, approximately 112 surveys were offered and reported cases. As you can see from the slide that's up there now, that the vast majority or the majority of those surveys address the issue of likelihood of confusion, followed by secondary meaning and other false advertising, genericness, fame and dilution surveys. With respect to the state-of-the-art survey evidence today, I believe that survey evidence is generally better today than it was 10 years ago. And I think it's due to three reasons. First was the Supreme Court's decision in DAUBERT versus Merrill Dow. There, I think the Supreme Court, in answering criticism about expert testimony, raised the bar for survey evidence, requiring and reminding federal judges that they had a gatekeeping function to determine that the evidence that was being offered was relevant and reliable before it could be admitted. In the next slide, you can see, although generally few surveys have been excluded under a DAUBERT challenge, I believe DAUBERT and the threat of DAUBERT has influenced some litigators and some survey experts to bring better evidence to the federal courts. Just for some comparison, we did a little analysis. You can see that in 13 and a half years before the Supreme Court decision in DAUBERT, 4 surveys were excluded for methodological reasons. That's about 1% of the surveys in reported cases. During the 13 and a half year period after the U.S. Supreme Court decision, you can see 25 surveys were excluded, and that represented about 4% of all of the surveys and reported decisions. So not a huge difference. In the last 6 years, we've had 14 surveys excluded, which is about 6%. But the 4 to 6% percentage, interestingly enough, this is one of these, it doesn't always apply to everyone. DAUBERT exclusions are most successful. Well, let me back up for a moment. It seems that DAUBERT and DAUBERT exclusions are sometimes circuit driven. The most successful DAUBERT motions have been in the Second Circuit. And absolutely, for all of you that practice here in the Ninth Circuit, you know the circuit doesn't believe that there's such a thing as DAUBERT. Everything goes to wait. This has never been a circuit that has been where you've been very successful with DAUBERT motions. Anyway, so that's the first thing. The second thing that I think has increased the reliability of survey evidence in the last 10 years is just the pure increasing volume of surveys being offered to the courts. And that really that's really making the courts more sophisticated. They're seeing more and more surveys being offered, and they're being forced to evaluate those. In addition to that, the courts now have everything from Sherry's chapter on the manual of scientific evidence to the manual on complex litigation, and hopefully the Swan Diamond book as well, to help them understand the concept of survey science and what's good survey science and what's bad. And from the quotes that you have up there, you can see how sophisticated the judiciary is starting to become. Those words just literally could not be found in opinions a decade ago. And finally, the third thing is that as the circuits have adopted factors for likelihood of confusion, for secondary mean, for genericness, courts are now looking at those factors and reading survey evidence in light of those factors, which I think is very helpful. Sherry?
We're sharing.
We're sharing, yes.
We're sharing. Okay, we're going back and forth, so we're going to share the mic as well. Well, from my perspective, I've heard people both be enormously enthusiastic about the burgeoning use of surveys and how wonderful they are, and how the judiciary is getting so sophisticated and they're able to handle this. And on the other hand, I heard, actually I even heard it yesterday, about being some dismay about the quality of surveys that are being offered, and about the inability of judges to parse through them when they are faced with analyzing them. And I guess I would say that the glass is sort of half full on these. We've come a long way from my favorite example is an early survey that was conducted in a bowling alley in front of, so the respondent was responding in the with an audience around her as she was answering the questions on the survey. We don't do that anymore, and you don't see those cases reported in the opinions. You see fewer cases where there are surveys offered that are where the data are collected right in front of the plaintiff's store, the defendant's display at a show. So we've come a long way in that respect. We also have seen an increased number, almost to an expectation of surveys that really shouldn't be called surveys. They should be called survey experiments, because they're testing causation. They're testing to see whether the allegedly infringing mark causes consumers to perceive it as coming from the wrong source. And so we have control groups, just like the medical people do in their medical studies, to test that causation. So we've come a long way in a number of areas. Some of the judges have gotten far more sophisticated, partly, as Jerry mentions, because of some experience. Some of them are actually going to seminars and workshops. This happened in the wake of DAUBERT. There started to be workshops. We have one at Northwestern where judges come in and learn a little bit about science, and this, I think, has a nice spillover effect as well. On the other hand, there are still some not very good surveys out there, and the courts do need some assistance in understanding the value of a well-done survey. In addition, there are some additional kinds of problems that have cropped up. So you get a critique of a survey, and as Professor McCarthy has often said, there's no such thing as a perfect survey. And the problem is that the courts have not been able to distinguish always between attributes of the survey that are really minor problems and things that are really significant problems. So they do need some help evaluating surveys and evaluating the research designs, and we're seeing, I think, more of that. There's some other fallout from DAUBERT. I think there are higher expectations on the part of courts. There are some problems with increasing costs, although, as I'll say a little while later, I think the internet surveys may be helping that, bring that down a bit in some cases. And then there is a greater suspicion as the judges have gotten to the point where they feel a little bit more comfortable. And we're seeing more cases, I think, with opposing surveys, which has increased that issue. So are they higher quality? I think on they mostly are higher quality, but we're going to show you some examples of things that didn't exactly meet muster, as well as some that did, and why that's so.
Okay, so we're going to move into a section of the presentation in which we look at some cases, some actual decisions, and see how the courts treated surveys that were offered into evidence. Before doing that, let us just be clear that some of you may have actually litigated these cases or played a role in these cases. The discussion that takes place up here is based on what was in the published record. So to the extent that there's more behind the scenes that we didn't have privy to, we're talking about what's in the published record.
But they're welcome to waive privilege.
But we'd love to hear at the cocktail hour the backstories.
So we're going to start with some examples of cases where surveys did not make the grade. And the way we'll walk through these is that Jerry will talk about the survey design and the fact pattern of the case, and then Sherry will analyze the court's opinion. So, Jerry?
Thank you, Eric. So the first one is Juicy Couture versus L'Oreal. Just give you a little background on this in this particular case. The issue had to do with some marks that the Lancôme line was using. Lancôme was founded in 1935, and over time its products evolved to include not only fragrances but makeup and skincare. Lancome's name and its rose design are used as its trade dress on every product that it sells. Its products are only sold at Lancome counters in department stores by Lancome personnel. In 1997, Juicy Couture began selling clothing under the Juicy, under a Juicy family of marks, if you will. In 2000, so that would be 3 years later, Lancome came out with a line of lipsticks that were sold under the marks Juicy Tube, Juicy Rouge, and Juicy Wear. At that point, Juicy sued, and they claimed likelihood of confusion on their registered as well as their unregistered trademarks. So, in this case, both plaintiff and defendant offered surveys. We're just really going to talk about the survey that was offered by the defendant. The plaintiff, Juicy Couture. Plaintiff's survey was conducted in shopping centers, so it was what is often referred to as a shopping mall or a shopping center intercept study. The survey universe were females, teenage and adult females, 16 to 39 years old, who had purchased cosmetics over $15 and who had purchased clothing in a department store over $50. Respondents were shown, interestingly enough, just the names, the alleged infringing marks on a card, 2 marks and 1 control mark. So they were shown, as you can see up on the screen, they were shown a card that said Juicy Wear on it. They were shown a card that had just Juicy on it, and they were shown a card that had had Glossy Wear on it. You can see there that the survey expert reported 27% confusion in the 2 test cells and 1% confusion in the control cell.
Okay, Sherry, how about the court's response?
Well, the court did not like this survey at all. The basic concerns with the survey included a problem with the population, that it was quite skewed, and therefore the sample that of respondents who participated in the survey was under-inclusive. The court also complained that the initial introductory question was biased. One of the initial questions, the introductory screener question, asked if they had purchased an item of clothing for over $50. I'm not sure who that screened, because my guess is that almost everybody would have qualified even in 2006, but let that pass. And the procedure was just a word association test. That was the third kind of complaint. From the court's point of view, there was a missing control, that is, that there was no control for the test cell item of Juicy, but that was a secondary point. So the interesting thing about this is this was a bench trial, but the judge said that she would have excluded the survey if it had been a jury trial, but of course gave no weight to this survey as well. Now, as an evaluation of what the court did in this case, for the most part, I think the court got the critiques pretty much right. The population issue was really kind of an unfortunate mistake on the part of the survey person. It turned out that a third of the survey sample was between 16 and 24, and 2/3 between 25 and 39, quite a young sample. The problem was that Lancome, it's 75% of Lancome customers who purchased that product are over 34. So there was a disconnect between the sample that was surveyed and the actual group. Now, there was some conflict about what the actual population that Lancôme was aiming at, so what might have been included. What they should have done was had a broader population qualification for their sample. The reason being that if there's some dispute about it, you can look at subparts of the population across different ages, but you're out of luck, as they were in this case, if you don't exclude people who are in the relevant population group. The court also correctly noted, I think, that cueing people, that the survey was going to involve material that was going to be in the survey is a framing error that occurs. Sometimes you see it in screeners, sometimes you see it in the initial questions that are put to the respondent in the main survey, and you don't want to be framing things in that way. And finally, there was the fact that they didn't have any context cues was a crucial kind of problem. The expert in this case kind of fudged things and turned it around and said, oh, well, this was really a post-sale confusion study, even though people who were participating in the survey were told that they should act as if they were making a purchase. So there was a disconnect there. But even so, as Jerry mentioned, the post-sale situation would have had cues that were indicative of other aspects, that it was a Lancôme product, so that them putting this just plain words on a piece of paper was clearly a mistake.
Okay. The next case, again, we're looking at cases that the surveys did not make the grade, is the U.S. Polo Association case. Jerry, can you walk us through the facts?
Sure. This was actually, just so you get the lay of the land here, this was a DJ action where the plaintiff was U.S. Polo Association. And they were asserting rights to both sell and license fragrances under three particular marks: U.S. Polo Association, the Double Horseman mark, and their 1890 mark. Ralph Lauren countersued for trademark infringement, unfair competition, and dilution. In this case, both plaintiffs and defendants did a survey, but Sherry and I are only going to talk about the DJ plaintiff survey. This was a shopping center intercept study. Approximately 1,000 interviews were done. Respondents were men and women, 18 to 35, who reported they were likely to purchase a fragrance costing between $20 and $30. The survey exhibits that were used in the survey were one of 5 fragrances. People saw both a fragrance and its box. In the 3 test cells, which are up on the screen now, there was, what was tested was a fragrance that had the Double Horseman above the USPA initials, the Double Horseman above the name U.S. Polo Association, and the Double Horseman with the U.S. Polo Association arched above the 1890 mark. As you can see from that slide, the survey expert reported finding confusion at 28, 27, and 25.5%. In the control cell, 2 different controls were employed. There were 2 separate surveys. So respondents saw one of 2 stimuli. In the first control cell, respondents were shown the U.S. Polo Association box with their the polo name and what has always been referred to as the U.S. Polo Association's horsehead logo. In the second control cell, they were shown a box and a bottle of the Beverly Hills Polo Club fragrance. You can see from this slide that the survey expert reported that the level of confusion in the control cell was 28.5% and 32% respectively. And as a result, because those numbers did not exceed the percentages in the test, he concluded there was no likelihood of confusion. Sharon?
The court was uncomfortable with this survey as well, both on grounds of the way the questions were worded and also on procedure, and it's a nice piece of procedure to keep in mind. And in addition, the third thing was improper controls. So just going through the preconditioning issue here, on the screener, there was a question about planning to purchase a fragrance in the $20 to $30 price range. And that the court said that that was an inappropriate thing to do. The second was the first question's wording, which was, what organization put out this product? Cueing the respondent in to the fact that an organization might be being looked for in the answer, kind of leading question. The failure to supply verbatim responses was an intriguing problem in this case. It's typical practice. Jerry does it all the time. I do it. You supply a complete set of the verbatim responses. Ordinarily, the notion is you're going to let the other side see what you've actually done and what was produced in it. Here, the judge complained about it because the judge wanted to look at the verbatim responses, and you get this underlying current of maybe a little bit of distrust. I want to see what the actual verbatims looked like that comes through in this opinion. And this I would consider the really big problem, which was the improper controls. Ordinarily, when we design a control, what we want to do is have as much as possible that is not at issue being present in the control, but nothing that is at issue. If you look back at the, can we go back to this? Yeah. I'm not sure that you can see this very well. These are the controls that were used, and in both of these, there is a prominently featured POLO attached on the face of the package in the same kind of lettering that Ralph Lauren used. And this is an example of where the control cells were in fact themselves likely to be infringing a registered mark about which should not have been present in the controls. So it's not very surprising that you got similar levels. Court finally was interested in the fact that the controls had a very high level, that is the 28%, and quotes a piece about when the control has evidence of confusion that's over 10%, then there's usually something wrong. I think that's inappropriate, and we'll see an example of that later.
Okay, so we've gone through a couple of examples where the surveys did not make the grade. Now we're going to turn to a couple where the survey did make the grade, and we'll follow the same approach here. So, Jerry, can you set us off on the RE/MAX case?
Sure. This is RE/MAX versus, excuse me, Trendsetter. I suspect lots of you sitting in the audience recognize that sign, or it looks familiar to you. It should. It looks very much like the RE/MAX sign. Plaintiff, in this case, alleged the defendant was using signage that was likely to cause confusion with with RE/MAX. The defendants were Realty in Houston, Texas, and plaintiff offered a survey to provide evidence of a likelihood of confusion. The survey was conducted in Houston among adults 18 years of age or older who had used a real estate agent or said they were likely to consider using one in the near future. It was a traditional two-cell study, so you had a test cell and a test cell group or experimental group, and you had a control cell group, and those were separate respondents. In the test cell, respondents saw the sign you just saw on the slide. Control cell respondents, and they saw a picture of that sign sitting on stuck on a post at a lawn in front of a house that was for sale. And in the control cell, they saw the same house, the same size sign, but the sign had been redacted of the red and blue. Is it blue?
Yeah.
Yep. The red and blue colors. All response were asked the same questions. Both the test cell and the control cell response were asked what company was being promoted by the sign, and was that company affiliated or connected with any other company, and if so, who, and what company gave permission for the sign. You can see from the slide that 25% approximately indicated they thought that the sign was from Remax, and in the test cell, and about 3% said they thought it was from Remax in the control cell. Sherry?
Yes.
Sorry.
So this was a very straightforward, clear kind of design, and the court was appreciative of the both selection of the population for the survey, the method of questioning, and the design of the control group, because all that was changed were the elimination of the colors red and blue. Could have done it with different colors, but that was in fact a legitimate way, as long as you could see the house outline, which you could in the control. And so everything was taken away except for these familiar and familiar placement of the colors that is used in Remax. The court reports that 25% confusion rate is sufficient, and rejected the notion that this would be dissipated later on. Initial confusion is good enough, even if it is in fact dissipated later on. And
Jerry?
so.
Can I just interrupt for a minute, because I was looking at that slide and I wanted to ask you and Jerry a question about that.
Yeah.
In particular, that the 25% was considered sufficient, because some members of our audience, I get called by trademark lawyers and they discuss this and they want to know sort of and my students ask me all the time, as a general rule of thumb, what's enough to either get past summary judgment or have a judge sort of take the survey seriously? What kind of ranges statistically?
Okay, so we have a complicated situation here, because the number that typically was bandied about was 15%, and that's a kind of rule of thumb that people have used. It's, I think, very misleading, and we'll talk about it a little bit later, but the idea of quoting these older cases for very low amounts. Some of probably were wrongly decided, but you can't lump together things that were done without control groups with studies that were done with control groups. So the question is, the only question that sort of makes sense is what is a minimum for a base, and even there it depends on the situation. But you raise a really important point. I stopped talking, but raise a really important point in that it does depend on the specifics, and it's the old kind of story of the devil's in the details on this as well. It's similar to the question of how big a sample do I need? Well, it depends, and so it's not a very good answer.
Very unsatisfying.
I know. Judges don't like it when you say to them, I can't tell you until you tell me more. They don't like that.
Yeah.
Jerry, of course, wrote the chapter reviewing all of the studies on the levels that have been accepted and not accepted in trademark surveys.
You take the mic. You want to, Jerry, do you want to say a word about levels?
I agree with Sherry. I think you can't really say, there really are no absolutes. And I really agree that it's very important to be careful that when you're looking at, let's say, the Jamesboro Limited case, which is a very famous case that had 15% confusion over a restaurant that was going to be called Home of the Beef. Sign of the Beefeater. The gin people sued. A study was done without a control and showed 15% confusion, and Judge Markey, in his concurring opinion, said that was a huge number. But But I don't think you can take that 15% and then put it up against the remix
Well,
case.
yeah, what's sort of dancing around in my head is that the legal standard is an appreciable number, right? In trademark law, which is a really strange word in trademark law. I don't think I see that word in any other area of the law. It's not, it's not used. It's not substantial. It's not significant. It's not trivial. It's appreciable. And so we don't really know what appreciable means, even definitionally in the abstract. And then we run into the surveys and we say, okay, is 15% appreciable? Is 17%? Is 30%? Why should there be injunctions when there's less than 50%? I mean, how we take it, a lot of these things are sort of given that the law has morphed in this direction. But there's no particular reason why it had to be these rules of thumb.
And should it matter how many units are being sold, right? Should percent of what? I mean, there are other ways to complicate it too.
Right, because it's basically a stepping stone, or it's an inferential tool to measure likely harm. And that's what could vary a lot, depending on the size and significance of the defendant and its operation. But I'm intrigued that, I've already become a person who accepts it as accepted wisdom. I tell my students, I say, well, maybe 17%. And they look at me and they go, why? And I say, well, you're going to find out from Sherry and Jerry.
Oh, we've already failed. We
Back it up,
failed.
17% is the number.
Well, in this case, it's kind of even worse in the sense that the court reports the gross amount and doesn't net out the control. So there's a little sloppiness out there in the courts on that score too.
I think you also have to recognize you have to read that percentage. You have to recognize you need to read that percentage in light of the confusion factors. I mean, this is only one element of a multi-factor test. And depending upon what those other elements, what the court concludes about those other elements, higher or lower numbers may support a finding or not support a finding of likelihood of confusion.
Yeah, and to that point, David, I would simply add that from a practitioner's standpoint, the number from your net survey result could be more or less important depending on how strong your evidence is on all those other factors.
Right.
It's absolutely critical. So the devil is in the details, and it varies case to case.
Let me just, the court was very impressed by the whys, and we see this back and forth, the responses to whys. And I have been always of the view that the whys can be very misleading, and that a strong research design, good controls, a good setup is probably much more important. And there's some wonderful examples from the RE/MAX case of people who said that the reason that they guessed that it was RE/MAX was because there was an R in the upper right-hand corner. Except there was no R in the right corner. So if you ask people whys, they will frequently give you a reason, and it may not be the reason that really caused their response in the first place. So the whys have a surface attraction, but are not always useful.
Sherry, I think actually, isn't there's some scientific evidence that there's some scholarly evidence that the why do you say that question that we can't verbalize as human beings.
Well, particularly if you think of a likelihood of confusion situation in which somebody thinks that this is the source, their ability to know what led them to think this was the source they just don't have the access to that. That's not the way they went around it, even though they're more than willing to give you an answer after the fact and try and figure out a good, reasonable reason why that must have been so. It's the causal errors in the wrong direction. So that is a problem. We just have one more slide on this one, or actually two more slides. This was a wonderful control, a very good control. So the question is, why would this be an inappropriate control? It's not RE/MAX. It's another real estate sign. And the idea is that the control should share features of the test stimulus, as many as possible, that are not at issue. And in addition, on this one, you want to avoid cues that will artificially depress responses. So if somebody can see and recognize a major brand and then can identify the response that way, then they're not going to say Remax in the control, and it would depress Remax. So this is an inappropriate kind of control for that reason. So we have the X across the next one.
Okay, the last case for where surveys were accepted is the Hershey chocolate case. Can we go through it pretty quickly?
Sure.
Jerry?
Yes, thank you. In this matter, Hershey's was trying to register the configuration of a candy bar. The examining attorney at the PTO refused registration on the basis of functionality. Hershey claimed trademark rights in a rectangular bar divided into 12 segments, equally sized segments, rectangular in shape, a 4x3 arrangement, and the segments had a recessed and a raised border. The next slide. In its appeal to the TTAB, Hershey offered a secondary meaning survey. This was an internet survey. It was of males and females, 18 years of age or older, who reported that in the prior 6 months they had purchased a chocolate bar, and also reported in the next 6 months they were likely to purchase a chocolate bar. As you can see from this slide, the test cell was shown the Hershey chocolate bar with the Hershey name redacted, and the control cell was shown a 1x3 panel bar. The survey results evidenced that a net of 42% of the respondents recognized the bar as Hershey.
Okay.
And the TTAB reversed the refusal of registration because they found distinctiveness, secondary meaning. The survey was one piece of evidence, but others were the length of the use of the mark and sales revenues and advertising expenditures. Now, they didn't comment on the internet nature of the survey, and this is not unusual. We are seeing increased numbers of internet surveys, but we sometimes the court doesn't make particular comment about it, as the TTAB didn't in this case. The survey was quite good in a number of respects. That is, the nature of the panel, and these surveys over the internet vary tremendously. Some of them are quite good, some of them are abysmal. You have to know the details about it. And the nature of this panel is quite good, quite heterogeneous. People were invited to participate in the survey without knowing the topic of the survey, a very important element. There was embedded information identification number when somebody participated so that they couldn't participate more than once, another important feature. And then surveys allow you to monitor the time somebody takes in order to answer the survey. And so you can tell if somebody's taken an inordinately long period of time. In this survey, they dropped 2 people. Now, it might be that your kids called you away in the middle of it, and there's a perfectly legitimate reason. But it also could be that somebody went and looked things up to answer the questions. So you do want to monitor this kind of thing. So those are good features of the survey. But let's take a closer look at the control group. The test cell had 83.8% Hershey, and the control cell had 42.4% Hershey. Now, first of all, those are very high numbers, but this is a second meaning survey. But Hershey is, of course, when you think of a chocolate bar, as an average chocolate bar consumer, Hershey might be the first name that comes to your mind. So it's not quite surprising that you have these high levels, which gets back to the point earlier about 10% in a control doesn't necessarily mean there's a problem. But if you look at the 3-panel chocolate that was used as a control, I would suggest to you that That doesn't look like any chocolate bar that you are likely to see. If you look at the one on the right, you can see Ghirardelli's shaped one, which only has 8 slices, 8 segments, but you could break off a piece easily and give it to your friend or take a quick bite when you're getting tired in a seminar or symposium, you know, something like that. It has a different look and feel to it, so you might argue that that would have been a better control.
Okay, real quick. Future of survey evidence. Jerry, what do you see as emerging issues?
I think we're all going to continue to see the impact of DAUBERT and the whole relevant, reliable questions. I think something that Sherry alluded to, I think that the courts are going to really focus, because it matches the Lanham Act, they're really going to start focusing on causality, and you're going to see more scientific surveys with test cells and control cells that are truly designed to measure causality. And finally, I think that in some ways courts are looking for empirical evidence when reviewing criticisms of surveys, as opposed to just the thoughts of another expert.
Other changes we've seen over the recent past in survey work have involved the decreasing response rates that all surveys are seeing, the family government surveys, the well thought out, done over a long period of time surveys. Everybody is experiencing much lower response rates. Accompanying this, we've also seen some research which suggests that we get pretty good results, that is, consistent results, even when response rates are fairly low. So we need to learn more about that, but I think the focus now is should be turning to the evaluation of potential biases rather than pure response rate kinds of issues. There have been huge changes in the way we survey, changes in purchasing patterns. So the mall intercept survey seems anachronistic in some respects for certain kinds of products and services. Changes in telephone usage, which mean that many of the younger people don't even have a landline to reach them, so cell phones are the way to go on those. And the powerful emergence of web-based surveys that we're seeing. I think that's kind of the trend toward the future. We'll have to be monitoring many of the things that mattered in the past, but courts are getting more sophisticated and paying more attention to. So details of the screener and its impact, the environment of the response, and framing of the questions, and then recognizing limits about what respondents can tell us about their thinking. So finally, the final screen has some potentially obstreperous kinds of observations, which is we tend to stick to the same old traditional accepted questions, and it may be that there'll be some times when we will want to branch out from that and try some different kinds of questions. There have been suggestions through the years about perhaps it would be good to narrow controversies between the experts before people spend huge amounts of money commissioning surveys that don't engage with each other. That would be nice. I'm not sure we're going to see that. And then you have Justice Breyer calling, and others calling for greater use of court-appointed experts. And that's kind of, I guess, a fear and a concern, but maybe an opportunity as well in the survey area. So that's the future.
Okay. So the next topic, I'm going to talk about trademark dilution surveys a little bit, and we'll jump over to that set here, and in the interest of saving some time, we'll just focus on a couple of key slides. The Trademark Dilution Revision Act of 2006 really framed the opportunity for continued survey work, additional survey work in the context of dilution. Of course, dilution, the concept of the erosion or whittling away of a brand. TDRA opened the door to surveying really in two areas. Number one, with respect to the fame component, right? The TDRA set a higher bar, did away with the concept of niche market fame, and said that in order to gain relief under this act, the Trademark Dilution Revision Act, the mark had to be generally recognized by U.S. consumers. And then the TDRA went on to explain that there were two types of dilution that were actionable. Dilution by blurring, that whittling away, that erosion of the strength of a mark to identify a source, and also tarnishment. So we'll just focus on those two areas, the fame question and the dilution by blurring issue. The Trade Dress Revision Act states, tells us what to measure, basically. It says that a mark is famous if it is widely recognized by the general consuming public. One thing to keep in mind while we're talking about dilution is that there is not a lot of case law to provide guidance on how to do these things. There is an absence of case law on how to do these kinds of things. But we get some guidance from the statute. Nevertheless, there is an open question about how to frame the fame-related questions in a survey. There's currently two schools of thought. One is the recognition school, which asks what are known in the business as aided questions. So there is something about the question or the setup that is provided to the respondent that provides context for the response. An example of an aided type question, if you were going to survey in the fountain pen category of products, might look something like this, where there's an array of products plus a control, and respondents are asked, which of the following pen brands do you recognize? The other school of thought is following a model that would ask recall type questions. So can you bring it out of the depths of your mind and recall what is a famous brand? These are unaided type questions, and they ask open questions such as, when thinking of the product category, like pens, which brands come to mind? We don't have any case law guidance on this. As a practitioner, I might recommend doing both and seeing how they go. But maybe the better approach is to go back to the statutory language, which talks about the widely recognized nature of famous marks. And perhaps at the end of the day, that is the right result, and the decisional law will play that out in the years to come. To David's question about how much is enough, we could do a whole seminar on that, as was made clear by the dialogue back and forth. We don't need to talk about it here. If you're in that middle ground and you have strong other evidence, you're probably okay. If you're on the either end of the spectrum, if you're very high, you might want to think about whether something went wrong in your survey. And if you're on the other end of the scale and get very low results, obviously you're going to need to do some work.
Eric, if I could just interrupt for a second. Well, how does amount differ in dilution than in confusion? Because, you know, in confusion, we have these rules of thumbs that get bandied about. What about in dilution cases? Likelihood of dilution? Is it the same? Sherry, Jerry, what do you?
You're just talking, he was just talking about fame at this point.
Okay, okay.
Two parts. We don't even have anything on fame.
About how much?
David, it's 17%.
Gosh, everything's 17%. Yeah, geez, it's easy to win these cases.
The point is, it's a multi-factor test. The survey work is one element of that, an important element of that, but it's just one element of a multi-factor test. So what are some other things to think about? Well, the universe is critical. The TDRA tells us that it is the general consuming public. There seems to be some thought in academic circles, some academic circles, that there still has to be a relevant consumer, correct? The statute talks about the consuming public, so maybe we get to niche in a little bit, but that also is unresolved in the decisional law. Keep in mind that the mark has to be famous as of the time that the diluter entered the market. That can be very difficult to survey if the diluter has been in the market for a long time. Sherry can speak to this, but it doesn't seem like there are very good ways using psychological methodologies to go back and measure whether people had that recognition in the past. Probably another topic for a Ouija board and another presentation for another day. So let's talk for just a minute about the other factor, the associational blurring. So this is the first type of dilution, blurring, not tarnishment. The statute provides some guidance, but not a heck of a lot. This is really just an indication under the TDRA that survey evidence is relevant. The Act talks about in its own multi-factor test for evaluating dilution, any actual association between the mark or the dilutive mark. So again, measuring dilution, measuring that association is a good basis for survey work. How to do it? Here, there's not quite the open debate that we saw on the fame side of things, but there are still different ways to approach this, and both scholarly works and some reported decisions have used and accepted both of these types of questions. One way to do it is to ask if the accused mark creates an association with the famous mark, and you can see some examples up on the slide. The other way is to ask if people are familiar with the accused mark, that is, people who would have been exposed to the accused dilutive mark, associated with both the junior and the senior users. The thing that is being measured here, the key to the test, is that we're looking for some kind of spontaneous association. That's the blurring. That's the harm to the mark, that erosion, that when people see this thing, this other thing, this dilutive mark, they have a spontaneous association with the senior user's rights. So, as we know, 17% is enough. There are some reported decisions out there talking about levels of levels of association that are sufficient to stand as evidence of dilution by blurring. This particular number, the 30.5%, we'll spend just a second on it. It's the Starbucks versus Wolf's case that's been raging in the Second Circuit and the Southern District of New York. It's the case that keeps on giving. The 30.5% number was mentioned in the Second Circuit's last remand as evidence of relevant evidence going to dilution. Judge Swain rejected that again on the remand, really attacking the methodology of the survey, and that survey had been, in this case, had been conducted out of context. She accepted the survey as some evidence, but gave it very little weight. And the case is back up at the Second Circuit. It was argued in January. There was a motion to consider additional evidence in February, and this one might be raging for another couple of years. So what are some of the questions here, the open questions going forward? Well, they're very similar to on the fame front. You've got to get these things right. You've got to get the proper universe. You have to make sure you're surveying the right people. The modality is an interesting question. As Sherry noted, courts really haven't seemed too troubled with the idea of using internet surveys. But you know, as the practitioner out there thinking about whether you're measuring the right people in a dilution context where we're talking about general consumers, think about modality and think about whether the internet or a mall intercept is more appropriate. Or maybe you do both. Controls, of course, are always important. So what's on the horizon and things to watch? Well, if Apple, Samsung taught us anything, it's that dilution of designs and trade dress are going to be more important in the years to come. There's an open question about what to do with house branding when evaluating the dilution question of blurring, and is it permissible or not permissible to remove marks from the accused mark or the accused design if it's a trade dress. And then limited audience or niche products. Just kind of an interesting think about it sometime. Does the dilution statute, does the TDRA simply eliminate certain categories of products from ever being famous? Products that are only targeted at women, products that are only targeted at men. Maybe so. There's lots of open questions. It's a fascinating area of law that's going to continue to develop in the years to come. With that, we'll turn it over to Eric and talk about deceptive advertising surveys and false advertising surveys.
Yeah, thank you. I don't get intimidated very often, but I am intimidated by my co-panelists here. We have look to my left, look to my right, and I've got experts on all sides, and then we've got me. So I'm not a trademark survey expert. I come at this actually from the advertising law perspective. I've been working with a co-author on a new casebook in advertising and marketing law. We are evangelizing this casebook and get people to teach the class throughout the nation. And obviously, as part of that, we have some materials on surveys. In fact, generally, I think of trademark laws as a category of advertising law. We have a chapter on trademarks, but only that in the casebook. And so I'm going to take a step back and put it in a little bit bigger context. If we're thinking about advertising law as such, what might we want to think about? Just before I get too far into it, I do want to recommend the book. I will be blogging my recommendations of this book. This book is I think, the book we all wanted and needed. It was, and I know this will sound odd, please don't laugh at me, this is just who I am. This was gripping. I was reading it, and every page was a page turner.
Was it the sex or the violence?
It was the statistics. Really, if you're doing any surveys, and I'm guessing in the room just about everyone is, you have to have this book. And it's, whatever exorbitant price that the public is charging, it's actually going to save you that much more on your exorbitant outside counsel. So it's a good deal in the end. Let me just talk a little bit about false advertising surveys as a contraposition to trademark surveys. In general, the similarities between trademark surveys and Lanham Act false advertising surveys are overweight or trump the dissimilarities. Most of the things that we would discuss would apply in toto to false advertising surveys. So I'm going to just pick out a few differences, but they're not really binary differences for the most part. They're more shades of gray or degrees of difference that might be worth thinking about. The main structural difference in false advertising surveys is that you're almost always dealing with a competitor. By definition, the Lanham Act false advertising cases are limited to competitors. Whereas there's a bunch of situations in trademark law where you may be doing surveys where your opponent is not a competitor. If you're dealing with a TTAB, a challenge to the trademark office action, there's not even a competitor in sight potentially. But even in your dilution cases, for example, many of the dilution cases won't involve competitors. They'll involve something else. I'm not sure who they are, but they're something else. Throughout everything I'm going to say for my limited remaining time, I'm going to, it all starts from the source that when we're doing false advertising surveys, we're dealing with a competitor involved, and I think that creates some possible changes. The only other thing I'll mention as a structural difference is that though it's not doctrinally hardwired into false advertising law, effectively a consumer survey is mandatory if you're doing an implied falsity case. You're going to have to show extrinsic evidence of what message consumers received, and the bottom line is you have almost no chance of convincing the trier of fact about what message consumers received if you don't actually get a survey of consumers. And in trademark law, there's lots of ways to overcome consumer surveys. In many cases, you can manufacture all kinds of garbage evidence, and if you can sell a judge, it's good evidence. But you know what I'm talking about. Come on, don't scoff at me. You guys know that there's a bunch of junk science out there and junk doctrines that can trump your need for a consumer survey in trademark law. But effectively in false advertising, it's a non-starter. You have to have it. The two main things I'm going to sketch out for you as differences in false advertising surveys is first, the range of inquiry, the questions that you're going to be asking and the scope of topics that you need consumer feedback about is bigger in false advertising than it is in trademark law. Now remember, this is not a binary thing. This is a degrees matter. But in trademark law, in many cases, you're going to ultimately be trying to answer very binary questions. Do consumers recognize this trademark or not? Is this trademark similar to a different trademark or not? Is one trademark associated with another trademark? These are yes or no questions that you can ask. Whereas in false advertising, in many cases, the consumer surveys are asking the question, what message did consumers receive? And that message is unbounded in what consumers can receive. And in fact, it's always fascinating when you do your focus groups or your panels of what people see out of an advertisement. The reality is that stuff that you could have never possibly imagined years as a message that consumers will get will show up in these discussions because there's a heterogeneous range of consumers, and many times claims have multiple meanings that can be attached to them. Survey questions in false advertising can often be even more open-ended than in trademarks. You're still going to have a funnel approach, but in fact your funnel might start out even bigger than it does in trademarks, leading to your closed-end questions. And because some products deal with heterogeneous consumer segments, they're not just targeting the one segment, but they might actually appeal to different segments in the marketplace. And you may need to have empirical evidence with respect to the message received in each of these segments. And sometimes it can just be that much more expensive. And you all know how expensive it can be. The other main difference, and again, difference in degree, not in kind, is in the testing environment, the way in which we approach trying to run the tests. The inquiry is trying to figure out what consumers, the prospective buyers, are going to do in the marketplace in response to the claims that they've been presented. And so we want to try to replicate the marketplace as close as possible. That's also true in trademark law. But here, because the claims can draw their meaning from a lot of different contexts, all the different ad copy that's been to date, all the contexts in which the product sits in the marketplace, all of that information feeds into how a consumer might interpret the claim. That every little fact matters. And so every fact that's presented in your survey environment is a potential basis on which someone say that wasn't a good replication in the marketplace, and it might actually have been, the basis on which consumers were not answering the questions accurately. And in fact, in false advertising, it's not atypical that you might have multiple ad copy at issue. So it isn't just that there was one ad that was run that advances the false claim. There might be multiple ads that have the same false claim. And then it might also be on the product. And all of that information feeds into the inquiry of what message consumers receive. So the goal is to always replicate the buying market as much as you can to try and figure out what it looks like. And a testing environment, by definition, is not a buying environment. So there's always this friction that's going to be built into the entire test that is quite pronounced in false advertising surveys. And the last thing, and we were already touched on this a little bit in this panel, but I'll just circle it as another place where false advertising takes it to the next level. Is with your controls, what you're presenting as a control. The goal is to isolate the effect of the claim and say, here's this claim, how did that change behavior? So we need to do a panel with the claim, and we need to do a panel without the claim. And depending on what the claim is and how it's presented to consumers, it might be very difficult to reverse engineer a control that is actually something like people would encounter in the marketplace. So you can imagine if you've got a television ad and it advances the claim in the television ad, it might be as simple as just muting the ad when that claim is made orally. Or it might be so deeply embedded in the ad, you cannot present that ad and modify it in a meaningful way. Or if it's a product in the marketplace, it might be that it's impossible to change the product and eliminate the claim that's on the product packaging or in another way without making it look like such a different product that it's not really isolating just the claim and the claim alone. I'll advance those thoughts for the further discussion, and I'm going to turn it over to the moderator.
David, time update.
I know. But this is going to go fast, really fast. I have a video. Wait, don't start it yet. Faisal Ahmad, who is my chief assistant here, student assistant, I said, I have a little video on surveys, and I want it to be fun. And so he actually called Seth MacFarlane. And Seth MacFarlane put this together with Faisal, and we're ready to watch it now.
What am I going to do about this trademark case? I have to prove a likelihood of confusion somehow. Maybe I'll rely on the power of the mark. No, that won't work. There has to be something better. I know. I'll get a survey. Wait a tick. Will it be too expensive? Will it prove confusion?
Survey? or not to survey? That is the question.
Okay, so that was about as successful as the award ceremony the other night. So the question I'm asking is, does this stuff matter? How many of you are trademark lawyers? Okay, like everybody. How many of you have done a survey in a case that you've worked on? How many of you have never done a survey? The vast majority have done surveys. Well, it's quite apparent that all of these surveys are not showing up in court, that you just identified, that there's a whole world of surveying going on. It's kind of, and the question is, why are they being done and what's happening to them? Okay, so what we find, and this is an amalgamation of some studies that have been done empirically to measure whether a survey has any impact on winning or losing a case, whether it's worth the client's money. And I'm not going to go into the details of who did all of this. I've got it. It's available on my slides, which you will have. But because of time, I just want to give you some facts. In a survey and a study done between 2000 and 2006 of over 500 reported judicial opinions in federal court for trademark confusion, only 16% of them discuss survey evidence. And another study that was done between January 1st, 2010 and February of this year, only 10% of them discussed survey evidence. If we go further, we find that there is no statistical significance between plaintiff merely submitting a survey and finding a likelihood of confusion, that is winning. We do find some evidence that defendants, if they submit a survey, are more likely to win. And obviously there's a lot of other variables that matter that would have to be measured, such as the strength of each party's case under the other factors in the Abercrombie continuum. Let me see here where we're at. I'm not going to go through all of this. There's also summary judgment. It appears to matter. You can stave off summary judgment with a survey, which is what you would expect. But whether you can actually win at trial, and the significance of it is not as prevalent as one would suspect. So the question that it raises for me is, it raises a lot of questions, but one of the questions it raises is, how are people proving likelihood of confusion in all these cases if they don't have surveys? If there's surveys only in 16% of the cases that are actually reported, you still got the reported decision decided by a judge based on essentially speculation and the evidence that my colleague here called manufactured. I wouldn't call it that. I would call it circumstantial evidence. And we have a whole area of law that's being decided routinely, like 85% of the time, based on speculation and circumstantial evidence. That raises a lot of questions from a law professor's point of view about kind of the validity of this area of law. And your answers, with all the surveys that aren't disclosed, raise questions about how all of that is done. I understand it's done for pilot work to understand the case better, but how all of those just don't get discovered in discovery. And I think that raises other questions about this area of law. So I just wanted to leave us with those provocative questions from a professor's point of view about the role or lack of a role that surveys are playing in actually determining the law.
Do we have time for questions?
Yes, let's take some questions. Questions from the audience. We'd love to have some people ask some questions. Line up. We'll take, 4 or 5 in a row behind the... If you want to just stand up, you can do that too, or shout it out, or interrupt somebody.
Hi.
Hi.
Thank you so much for the presentation. It was great. My name is Jessica Pfeiffer. I work at the University of San Francisco, and I have a question. In the event that your client conducts a survey and you believe it's reliable, but the survey is not favorable, is it common practice just to scrap that survey, start over again? And if so, how do you deal with that in discovery, and are there ethical considerations?
What are you looking at me for? It's a fair question, and David alluded to it just a minute ago. So we've all done a lot of surveys, right? And they don't all end up in published decisions. So I think that sometimes surveys can help clients understand the strength of a case, the weaknesses of a case, and could facilitate settlement. Pilot work is a legitimate thing, though, that being said. And David alluded to this. And pilot or pre-test that we won't go out and do a full-blown survey, but we'll try this question set out. And it can provide valuable information about whether you are asking reliable, relevant questions going forward. You know, I'm not gonna go all the way into to the water there, but I think that at the other end of the spectrum, there is value to pre-test work. There is value to getting survey results that are contrary to the end results your client would like to have, and there is value to going out and surveying more than once. I
think that's a fair.
Any other questions? I would ask questions of the audience. How do you, I guess it's a lot to ask you, but how do you prove your likelihood of confusion cases if you don't have numerical, empirical evidence?
You just claim initial interest confusion. You can't argue against that.
Oh, okay, good tip.
By the way, I should add that the initial interest confusion doctrine is almost never working in court. And I've done a blog post on that, but I haven't seen a winning case of that in, I think, at least a year.
Peter Harvey.
David, isn't the answer to your question that it's not circumstantial evidence, you're simply putting in direct evidence that goes to further exclude that fact? I mean, we're talking about your evidence. Sure, it's great to have a survey, but surveys are expensive. Some clients can't afford it, just go with what you've got and put in your direct evidence.
So yeah, the sleek craft factor of we go to like similarity of the marks, similarity of the markets, sophistication of the consumers, so on and so forth. And but from that, the judge is supposed to make a deduction that is essentially an empirical deduction, right? And it doesn't necessarily follow that if you put the inputs into all those factors, that deduction should come out of the from the equation.
And David, I would add that especially in these secondary meaning cases with these descriptive trademarks, the standards that the courts accept are just embarrassing.
What do you mean?
In a sense, you know, they might say, well, you advertise it a lot, or, you know, you've been around a while. Well, okay, that doesn't tell us anything about what consumers think, especially with these descriptive marks where they're words from the dictionary strung together.
I think we need more surveys that are admissible in evidence. I think that we need a market for them where online surveys become really good and cheaper so that it can be done and with a court-appointed expert. I don't know. But we need to get better empirical evidence out and about in these cases. So that would be my recommendation.
So that's the academic response. I'm just curious, how many people in the audience would favor greater use of court-appointed experts?
No, they don't like that.
That's what I thought.
Not seeing a lot of hands.
All right. I tried. Do we have another question? Yes, sir.
Yes, what is your view of counsel as a work product, hiring a survey expert in order to render advice and the production of that survey in discovery?
Well, I think if the counsel, the discovery or the disclosure survey, as I understand it, is not necessary if it was commissioned by outside counsel, communicated with in-house counsel, and that's kind of the end of it. If a fact witness at the company, a non-lawyer, knows about the survey, approved the payment for the survey, and ends up the subject of a deposition, he or she has to discuss the survey. Is that a correct rendition of the obligations?
Yes.
All right. I think we got to cut it off and move on. Thank you.
Well, it was fine.
be very stressful.